Welcome back to Sunrise. Thank you so very much for staying with us here on CVM See It Happen. It's time for another segment of Law and Order JA. The question sent to us this morning reads as follows. My name is Nadine and I'm a business manager operating out of Montego Bay. A lot has been said about improving productivity in Jamaica, especially as businesses like mine face increasing pressure to stay competitive. But many of us still struggle with the understanding of how to tackle this issue effectively. So, my question, Miss Kitty, is how does the law support employers who seek to improve productivity, and what legal steps can we take when faced with unproductive employees? We have with us this morning managing partner at Duncox Attorneys at Law, Emile Leiber, also former president of the Jamaica Bar Association, and Matuta too. So, yeah, former Tuta. Good morning, sir. How are you?
Good morning. I'm fine, thanks.
Welcome.
Thanks for having me.
Lovely. Well, normally, questions are posed from the perspective of the employee seeking a remedy or seeking some kind of redress. But this young lady, Nadine, is the employer who is faced with, you know, unproductive or low-performing employees. What law or structure do we have in Jamaica to protect the employer?
Well, the simple answer to that is none. So our laws are primarily from the 1970s. And it's really geared towards employee benefits. So we really have not legislated productivity in Jamaica. You know, so the employers are left with contracts, basically. So the employer has the obligation to really formulate policies, performance policies, proper job descriptions, proper assessments. You know, one of the things that I see time and again is that an employer will come to me and say, well, this employee isn't performing. So I said, show me the file. There's either no file or it actually has glowing reviews. And he said, you know, you really have to, you know, start where you want to end. So you really need a proper contract, step one.
Yes.
You know, you need a proper job description. What do you really want this employee to do? You know, you need to think it through. And a lot of small business owners, they're so focused on bringing in the money and making things work and so on and everything, which you understand, you know, but you do need to pause and think, what do I need this employee to do? If it's even a cashier, if it's a bearer, what exactly are there what they call deliverables?
Right, right.
What, you know, because a lot of times you have the expectations in your head, you know, but it doesn't actually translate. Exactly, right.
So let me ask you though, Mr. Leiber, talk to me a little bit about, well, you mentioned contracts earlier. What are some important clauses, or just generally speaking, because obviously if you want to get details, you have to seek an attorney at law, right? So what general clauses can employers have as a mode of protection? So
geared towards performance, it needs to state specifically in the contract what their job is. You know, because sometimes that's actually less clear. You also need to have in the contracts, now, particularly a small business, that your requirements or job obligation may be a bit variable.
Yeah.
You know, because you do need to have some flexibility in a small business environment, right? Because sometimes you're the bearer, but you're also, the, you know, you answer the phone sometimes.
Right, right.
You know, so your contract needs to actually state specifically what your potential range of duties might be. And then also,
them can't get thing like, that's not in my JD.
Exactly.
They're not paying for that.
Exactly. You know, so you can't just impose new obligations. You can't rewrite the contract in your head, basically. You know, so the contract needs to be worded broadly enough that it covers the things that you anticipate and need to update it, you know. So if your business grows and develops and so on, sometimes so you have a contract from 10 years ago that really doesn't match what the employee is doing now.
True.
You know, so you need to have that updated on the review, and you need to have that policy. What's your policies are different from your contracts, right? Because your policies really, your contract sets out what I call the basics of life, you know, your hours of work, days of work, the name of your job, who you report to, and salary, of course, very important.
Right.
But your policies are really that foundation that really guides a workplace, you know, and you need to have those policies and performance assessment structures to get what you want out of the workplace.
So we're talking about now the contracts, and this is an important part because a lot of employers fear, if there's an employee, you've spoken to them time and again, but there is no reform, there's no, redress, or, they're not, altering and performing, them still come late, they're still always absent. A lot of employers fear getting slapped with unfair dismissal. How can employers protect themselves against that? You spoke about, having a file, so to speak, a document to show I've spoken to this person over and over. So you have some protection for yourself. What else can they do?
So in addition to that, and that's very important, document, because, this thing about I've spoken to you, every hearing the employee is innocent, right?
Yes.
So, we I guess people generally don't really readily admit guilt,
yes.
right? So you need to have a disciplinary policy in place, a performance management policy. So there's a concept called a performance improvement plan. So one of the things, if you want to have what I call a justifiable dismissal for poor performance, you have to show that you brought the concern to the employee's attention and you give them an opportunity to change. Because the starting point in employment law is to preserve employment, right? And so if you have an employee who has been working with you for years, if you can improve their performance and so they stay in the job, that's better, right? But so if you're going to separate, you have to show that you have given them that opportunity to improve for a specified period, usually roughly about 3 months or so, depending on the nature of the issue, and they have not done it.
Right.
And then at the end of that assessment period, then you have to have it's arguable sometimes that you have a disciplinary hearing or a performance meeting, but certainly the employee has to have the opportunity to be confronted with the concerns and to respond and potentially have a representative and that type of thing.
So all of this will add up to due process if it does come to the end. At the end of it, you can say, hello, documents. Remember this? Yes. But just to say you've spoken to the person, that doesn't really help your situation. Just in terms of, just guidelines for employers, because as you mentioned, the laws really are skewed toward protecting employees. Just generally overview, Emil, what would you say to an employer right now to protect themselves and to, ensure that if there is a problem, you have some leg to stand on too?
Well, the first thing, of course, get good advice, right? A lot of employers start out with these templates from the internet, and nowadays with AI and so on. No, these things can do a lot as a starting point, but you need to have them vetted. Yeah. So even if you want to self-help and so on, which, everybody wants to save a little money, and that's fine, have them vetted. So, even if you have created these contracts, policies, and so on, like a lot of the things on the internet are US-based. Yeah. America has what they call at-will employment. So they have a different structure where they can tell you go, without process, right? So if you take these templates off the internet and ask GPT how to do this and that and so on, they may give you an American skewed concept. Then you also have to appreciate that you have a lot of things in employment space now, sexual harassment, data protection, and a lot of different things that you actually have to document, and the law requires you to document disabilities, of course, and various other things, non-discrimination issues. So you do need to have that vetting process, and then you have the application process. So some people have right documents, but they don't do the training. Because a lot of managers don't actually know how to assess employees properly, right? So I'm like, I don't like you from morning, you stay so bad, and you're like, no, an assessment is an objective set of criteria that, you measure the employee against. So conducting the assessment properly, and then you have that whole culture of fear in Jamaica as well. Boy, if I give them a bad assessment, I don't know what might happen and so on. So you do have to create an environment where you create the right set of papers, and then you apply it properly.
All right, very well articulated, well said, sir. That's why he was my teacher, I gotta tell you. Thank you so very much for being here, and thank you for distilling the issues. I hope that helped you, Nadine, and other Nadines out there who may want information. Special thanks to our wonderful sponsor, the Ministry of National Security. That was Emil Leiber, Managing Partner at Dunkirk's Attorneys at Law. Remember to keep those legal questions coming to us by sending them to our socials at Sunrise CVM. We'll be right back.